Hello, everybody who's here. Good afternoon. My name is Kenneth. We are just about to start our session. Top 5 pitfalls on copyright for media creatives. We have very much an overwhelming response to today's session, this afternoon session. So we will be spending some time to guest admitting our participants for today. If in the meanwhile, perhaps, if you are in the creative, I hope most of you are in the media and creative business and sectors, whether you are part of a company or you are an individual as a freelancer. Perhaps you want to, think about some questions that you might have. At the end of the session, see whether these questions have been answered. We will try to go through some of the questions that you may have. And with regards to the questions, I will ask you guys to put it onto the Q&A column, Q&A session. You can see there's a Q&A part down there, and just list your question if you have any. And I will try to put these questions to Paul, who will be speaking. So the time now is 3 o'clock. Like I said, just give us maybe about 2 to 5 minutes or so to get everybody on board, and we will start the session proper. So anyway, thank you for spending this afternoon with us for the next 1 hour. We will just be waiting for more people to join us, and we'll start the session approximately about 3:05. Thank you. Hello, everybody. Good afternoon. Thank you for joining us this afternoon and spending some time with us for the next 1 hour. This session is jointly organized by IPRO and IPOS International, supported by IPOS, the Intellectual Property Office of Singapore. I am Kenneth, your host and moderator for today. I am the Executive Director of IPRO. IPRO is actually the Association of Independent Producers here in Singapore. We represent some close to 70 independent production companies, content creators, companies, SMEs, who are form as member companies, right? So what we do as an association is we advocate for our member companies in regards to going through perhaps with the stakeholders like MediaCorp here in Singapore and networks that are based here, or people like Discovery, NetGeo, View, as well as we organize sessions like this to engage companies who are in the industry, who are media creatives, who are in the media sector, to perhaps to expound on certain things that we are always encountered in the day in, day outs of our work. On top of that, we also have a little bit of a networking session that is organized closed sessions that we have together with stakeholders like the IMDA, like I mentioned, the networks, to engage and to perhaps let our members know, right, more about them, and on their side to know who is doing what in this area. So a little plug-in of us in the association. I'm sure you know our friends and partners with IPOS. Today's session, top 5 pitfalls on copyright for the media and creative industry. I think as media creative, here what we always encounter, you must remember that we are, coming up with, at the end of the day, a piece of work that is something that is very much ours. If you are a writer or if you're a producer, something that we create for the company. So this production or this work of, how is it protected? How is it able to allow you as an individual or company to perhaps monetize it to the wider audience? The reach can be more, and then you can perhaps get some money. Not perhaps, but your intent is not to have this particular title or work being done one time and just sits on the shelf, but you want it to be monetized. And in doing so, how to protect it? What are things to look out for when you negotiate with someone from a counterparty, whether they are trying to license your product, license your work, and perhaps even to go to the area of syndication, how these titles can go beyond our shores. So these are some of the issues that we need to know about. We will try to deal with it, but just before I introduce Paul, our speaker for today, I'd just like to lay some ground rules. You are obviously muted, but don't worry. You will be, obviously, if you have any questions along the way, please put it onto the Q&A portion, not the chat portion, but the Q&A portion of our session for today. And we will spend some time to go through that. So how you will be like in the next 40 minutes or so, Paul will be going through with us, and then we'll take some time, about 10 minutes, to take your questions. And then at the end of the day, don't leave it as a yet. We will, perhaps there's a poll that you can help to us so that we can do better, right? Without further ado, I want to introduce our speaker for today, Paul. Paul McLachlan is a Commonwealth qualified solicitor, right, specializing in intellectual property law and commercial dispute resolution. So he is a subject matter expert. Right? And before joining IP Academy, Paul was a sole corporate counsel for a well-known Singaporean brand, where he was responsible for a broad range of commercial matters, including worldwide trademark registrations and even oppositions, management of external counsel, contract review and training and all that. During that time there, he was also actively involved in the first Singaporean case that concerns ownership of a domain name. So he has experience working in the private sector for both Singapore and Scottish law firms. So his name gives you a hint where he comes from. And his practice focused, like I said, on intellectual property and commercial arbitration, including IP portfolio management, trademark oppositions, and enforcement of trademark, copyright, and design. So Paul is also a faculty member of IPOS Academy, and he has taught commercial law, intellectual property, and real estate law even at Scottish University. So without further ado, Paul, over to you. I'll leave the session.
Okay, thank you, Kenneth, and hello everyone. Welcome to the webinar today. Thank you for joining us on this happy Friday afternoon. Looking forward to the weekend, but before we do that, what we're going to do is have a bit of a kind of informal discussion, a bit of a chat maybe about the pitfalls that you might face in administering and generating content in terms of copyright. So as Kenneth said, my name is Paul. Feel free to ask questions in the Q&A. I'll either just address them on air, or I'll just type the answer if I can. Okay, so just to start off with, we'll have varying levels, I'm sure, of individuals in today's session that know different aspects of intellectual property. So some of you may be familiar with copyright, some of you may have heard of it, some of you may have dealt with it before, some of you may think you know something about it, but maybe you don't. Some of you don't know anything about it, and some of you may be experts. So wide variety of people. I just wanted to give you, before we started, a kind of baseline for everyone to work from. So copyright is a form of intellectual property. It sits alongside things like patents, registered designs, trademarks, and confidential information. Now, most businesses have a collection of all of these different types of intellectual property. So some businesses, for example, accounting firms and law firms, focus more on the confidential information side. Some firms, such as Intel, focus on patents. Some companies, such as TWGT, focus on trademarks. But your guys' business is likely to be focused or centered around copyright. So that's why we're talking about this today. Copyright is, in essence, a fairly straightforward thing to understand on the surface, but a difficult thing to get to terms with on a deeper level. So on a surface level, copyright exists whenever you have an original intellectual creation that exists in tangible form. So as soon as you write down, for example, an email, or as soon as you draft a screenplay, or as soon as you tattoo something onto your arm, you're creating copyright in some form. So these are the basic requirements. Now, the key part about this to note is that copyright, and you'll probably be aware of this, but copyright does not require any form of registration, which is good because it means you don't have to incur any expenses to get copyright, but it's also bad because it makes it harder to manage it and to deal with it. Okay, so these three things. Copyright protects original intellectual creations, but it doesn't protect basic facts about the universe or ideas or anything that isn't the produce of the person who is making the thing. So it doesn't protect things like facts, it doesn't protect things like ideas, and it doesn't protect things like discoveries. Okay, so this is quite a fundamental thing to understand in terms of copyright. It's actually the most difficult thing to understand. So for example, I'm showing you here an image that is showing the cover of Walt Disney Studios' A Bug's Life film, and I'm also showing you DreamWorks' Ants film. Now, in terms of copyright, we're just going to do a little bit of analysis for these films. So both of these films, you may have seen them, both of them concern an ant who causes trouble within his ant colony. He gets kicked out of the colony. He goes away on a journey of exile. He comes across a ragtag group of friends. He decides to return to the colony for whatever reason. He finds that the colony has been overrun by an invasive species, locust, and he saves the day. Okay, and then he gets to marry the princess. In both of these films that came out in the same year. So you might be asking, why is this not a copyright issue? Why did nobody have a problem with this one? Well, the answer is that the intellectual expression, the way that these stories were told, has been done differently. So you'll see in A Bug's Life, for example, we use a blue ant who's quite rounded. He's fairly intellectual. He's not very physically powerful. It's very colorful, very bright, very cartoony, and all of these sort of things. Whereas in Ants, we have a militaristic society with a much more drab color scheme. The grass is less green on that side. and we have a sort of solution that is developed by brute force. So they use their military might to defeat the enemy in the end. Okay, so the expression of the idea in both of these cases was totally different. So this is the hard part to understand about copyright. So for example, if you have a telephone directory, you probably don't attract any copyright in that telephone directory because it's just a list of names. But if you have an inventive compilation of facts, like an encyclopedia, then it does attract copyright to some extent. Okay, so this is one of the hard parts to understand. I'm sure I don't have enough time, I think, today to go through every description or answer every question in relation to this, but it is an important thing to try and understand as we talk about licensing and other things to do with copyright. Okay, so without further ado, I'll go into the top 5 pitfalls. Now, I'm saying top 5 pitfalls. They may not be your pitfalls, okay? So they may not be your top 5. They're the top 5 from my perspective as a copyright lawyer. So these are the ones that most often I've had clients or I've had to answer questions about these particular topics or the things that cause trouble for people. If you have any other pitfalls that you want to highlight, then ask in the Q&A. Okay, so I was asking, what does copyright really protect? So it protects original, artistic, literary, dramatic, or musical work. It protects the expression that you give to that work. So what I'm basically saying is that anyone can write a story about a boy who gets a scar on his forehead and then later on finds out that he's a wizard and goes to wizarding school. What you can't do is frame it in the same way as Harry Potter and use the words that that person has used. So this is it's a complex topic. It's not one that you can probably understand within an hour. There are university courses that last an entire semester just looking at copyright. So it's not something you're going to understand fully just now if you don't already get it. But I'm just going to move on to some of the more easy to address answers. Okay, so the first thing about copyright that I often have questions about is that people don't understand what they're agreeing to. So pitfall number 1 is agreeing to stuff that you don't understand. Now, this is probably a general life rule rather than a copyright rule, but in copyright, there are some specific matters that you would want to pay attention to when you're negotiating with someone to make sure that you don't end up doing something that you didn't intend to do. Okay, so for example, when you upload stuff to YouTube, do you know exactly what rights you're giving YouTube and how that would impact on the other contracts that you've signed? So say, for example, if you sign, and you may already be aware of this, it may be straightforward for you, but one of the things that I find people don't understand is that if they've granted an exclusive license, for example, if you grant an exclusive license for your program to MediaCorp, that would exclude you from then uploading that material to YouTube. Probably because it says it in the contract with MediaCorp, but even if it didn't, the exclusive nature of the contract with MediaCorp would preclude you uploading to YouTube because this one, as you can see, is a non-exclusive license and it would be contradictory to the terms. So in this case, you really need to understand what all the terms mean. So what does non-exclusive mean? What does royalty-free mean? What is sub-licensable? What is transferable? And what is the purpose that you can do these things for? Be aware of the rights that you're granting to other people and don't just blindly do things, okay? If you upload it to YouTube, that basically means that you intend to monetize it on YouTube and you don't really have many other routes in that case. Also, you might come across a more complicated license. So this is actually, believe it or not, a simple structure of an IP licensing agreement. You'll see all the different sections that go through this agreement. Now, you might be familiar with some of these things, you might not. But I think what I wanted to get across to you is it's important to understand what all of this stuff does. So especially you'll see in the box that is entitled Grant of Rights. There are various things that you would want to get right. Okay, so you want to get right the type of license that you're granting. Are you granting exclusive, non-exclusive, or sole? What is the scope of the license that you're granting? Are you allowing the person to reproduce it only, or are you allowing them to adapt it? For example, if you're a musician and you're recording the lyrics to a song, are you giving away the rights for someone to change the lyrics to the song to suit them? So that has actually happened in Singapore, and there was a case about that in 2011. You also want to get the territory right, the duration of the right, and the revocability. So revocability refers to whether the person can terminate the license at will. Okay, so these are all things you need to understand. And again, I don't necessarily have enough time to go through each of them in this session, but just bear this in mind. Okay, interesting question coming in from anonymous attendee. That's a good name. So the question that has come in from anonymous attendee is that, can I elaborate more on the subject of copyright for compilations of facts? So this person comes from an industry where data and facts are compiled in a database for the purposes of machine learning. Now, this is a very important emerging issue for copyright, and it comes up quite often. So basically, the rule is that an arbitrary collection of facts does not generally attract copyright. So if you simply have a list of pieces of information that are compiled in an arbitrary and uncreative way, that compilation would not attract copyright. So the best example I can give of that is a telephone directory where it starts at A, ends at Z, and there's no freedom of choice. Now, if there is some freedom of choice for the author, and they start doing things in their own way, then they're giving some expression, they're giving some intellectual component to that compilation. So if I'm arranging this data, or if I'm selecting it for its certain qualities, then there's a chance that I would get copyright in that thing. So there's no database right specifically in Singapore. So if you're in Europe, there is a database right. In Singapore, we don't have one, but if there is an element of creativity in the way that you've compiled the information or the way the information is put together, then it may attract copyright. The other interesting issue with that point is that in terms of machine learning is, what about the output of the machine learning? So you end up with you've got a data set, you filter it through the machine learning process, and you end up with the AI file, basically the process file at the end of the day. The question is there any copyright in the AI file at the end of the day? And the answer to that is very complicated because it depends on a number of factors, but there may be protection for that also in copyright. Okay, so I'm happy to talk about this more later on, but maybe I'll just get through the main part of the slides just now. So the other thing I wanted to say about contracts is that, especially with IP related contracts, is that you need to understand the law that applies. So laws are generally territorial, meaning that you are only subject to the laws of the country that you are in. So you're only subject to Singaporean laws. You're not subject to Thai laws right now because you're situated in Singapore. That goes the same in general for all intellectual property and contract laws. However, with IP, especially in copyright, there is an opportunity for an international dimension to appear, which means that if copyright is created in the UK, it is enforceable in Singapore. Okay, so what that means also is that if copyright is created in Singapore, you can enforce it in the UK because of something called the Berne Convention. Now, when you're negotiating contracts, that is an important feature to understand. I think probably most of you know that already, that your copyright is fairly international. The thing that you might not get is at the end of the contract, it will say this contract is governed by the laws of, and then a country name. It will say by the laws of the Republic of Singapore or by the laws of Malaysia or whatever. Now, why that's important is because it may end up changing the venue of where the contract is disputed, changing where you go to sue the person. So for IP laws, when you're seeking to sue someone for infringement, that's not a contractual matter. Generally, you would sue them in the country where they are doing the bad thing. But a contract will be enforced in the country where the person paying for the contract is. So these are important considerations, slightly legalistic considerations, but again, important to understand. Just to give you a concrete example of how this can affect your rights, affect the way that you do business, or affect the way that you interact with services. This is Facebook's terms of service. Maybe this is out of date now, but this was at one point in their terms of service. So you can see the first point, it says, if you're a consumer, the laws of the country in which you reside will apply to the claim. In all other cases, i.e. if you're not a consumer, you submit to the US District Court for the Northern District of California. Okay, so in this case, they're splitting up the parties that they're dealing with. And what this means is if you deal with Facebook not as a consumer, then if you want to sue them, you have to go to California. That's a bit of a pain for you, right? Okay, so that is the first pitfall. So make sure you're understanding the terms. I think the key fact or the key takeaway from this one is if you don't understand one of the terms in a licensing agreement, do some reading about it. Don't just sign away your rights, because you could end up in a situation that you don't want to be in. Okay, issue number 2 is misunderstanding what's called the bundle of rights in copyright. Okay, what is the bundle of rights? Well, copyright is not just some monolithic thing, right? It's not just some giant legal right called copyright. Actually, it's a lot of miniature rights inside of the Copyright Act. The first thing we have to do when we're assessing what rights are in the bundle of rights is to work out what type of work you are creating or trying to use. So there are broadly 8 categories of works and entrepreneurial rights. These are artistic works, literary works, dramatic works, musical works, arrangements, sound recordings and films, broadcast and cable programs, and live performances. Now, all of these are important rights, and you would need to look at what you are creating and determine which ones are in it. So, for example, if you are a music producer, you will be recording the literary work, which is the lyrics of the song that you're recording. You'll be recording the musical work, which is the notes of the song, and you'll also be producing a sound recording. So in one piece of work, you will have 3 different types of copyright rights to address. Okay, just a few questions coming in. I'll maybe just answer them as they go so they don't stack up on me or people don't feel like I'm missing them out. So question here, if you're doing a blog article and you need to take facts and stats from any website, is that considered copyright? Also during news reporting, taking information from other sources, is that considered copyright if we credit the source? So taking information and facts and statistics from websites is not copyright infringement. You're not copying the creative mojo of that person, right? You're copying merely a fact that exists. So if I tell someone that my name is Paul is simply a fact. You want to repeat my name, you can repeat my name. For news reporting, there is a specific exception in the Copyright Act for the reporting something for the purposes of current events reporting. In that case, you can use a reasonable portion of the work, so a small amount of the work if you credit the source, yeah. So good point on that one. Okay, another question here about if a publisher gives an exclusive right to a book, what can I do and not do, and what to do next? So in that case, if a publisher, I assume what you're saying is that if the publisher gives you an exclusive right to adapt their work into a film or TV series or something like that, in that case, it would mean that you were the only party for that period of time who would be allowed that right. So the author would not be able to give another person the right to adapt or produce that work. Now, this is where it's important to understand the bundle of rights that I'm about to talk about. Because within copyright, and there's this very scary table that I'm putting on the screen, within copyright, there are a number of different rights that you can separate out and license into different people. Okay, so if you get from a publisher the exclusive right to make an adaptation, so you can see at the bottom left-hand corner of the screen, there is the entry that says make adaptation. And in relation to literary works, that is something that the author can control. So there's a tick mark in the box beside make adaptation. Now, if I simply get the exclusive right to make an adaptation, it does not mean that the author of the book would not be entitled to issue someone else with an exclusive license to reproduce the book. Okay, so the author can split up those two things. I'm giving you the exclusive right to make an adaptation, and I'm giving you the exclusive right to make reproductions of the book. So this is why it's vital for you to understand the bundle of rights here. So the reproduction, publication, performance, communication, adaptation, and commercial rental. Because maybe you get the wrong ones, or maybe you don't get all of the rights that are necessary for whatever it is you intend to do. And if you don't get that, then you can find yourself in trouble, or you could find yourself stuck in a corner, basically. You don't want to do that. So just make sure that you are getting in the license, it says a worldwide exclusive irrevocable license to ... What do you want? Do you want to copy the thing? Do you want to adapt the thing? Do you want to perform the thing? Make sure you state that very clearly so that you know exactly what your rights are. Okay, so okay, here's a common question coming in. For music, how much of the copying will infringe the rights in the copyright? There's no concrete answer to that. There is unfortunately no concrete answer to that. You may, if you want to find an example of an analysis of how that would operate, you can look at the recent example of the Stairway to Heaven case that was concluded in the US. So that was a case where a band called Taurus sued Led Zeppelin for infringement of one of their songs, which they said that Stairway to Heaven was an infringement. The court, the Federal Circuit Court eventually said it was not an infringement of the copyright, and you can look at that case to see how they actually addressed that problem. Again, it's a bigger topic than we have time for today, so I'm happy to answer questions about it, but it's not something that I can fully go in today. Maybe what I can do today is give you an example of where you would need to consider all of these bundle of rights. So how do you consider which bundle of rights or which parts of the rights we need to pick up and deal with? So I was trying to think, obviously I'm not in the creative industry, so I'm not totally familiar with the way that you would operate the business model. So say I took an example and tried to think through of if I was creating a television program for broadcast, what rights would be involved and who would own those rights? So first of all, I started off with a novel here, which is a literary work for the purposes of copyright. The ownership for that would be the author. I then want to adapt that, which is one of the copyright bundle of rights. I then want to adapt it into a screenplay, which is a dramatic work. So the adaptation, the copyright would belong to the writer, but they would need to seek permission to do that adaptation from the original creator. The screenplay is then turned into a film by the producers. So the producers then own the cinematograph film, requiring a right to reproduce the screenplay and a right to adapt the novel. They also probably integrate a soundtrack, which is the literary and musical works, into the film. There will also be, if you've ever filmed outdoors, you'll know that there is always going to be stuff going on in the background of your filming, and these would be called incidental inclusions of artistic works. These are not anything to worry about in copyright, but I'm just pointing out here, you are also reproducing these. That film would then go into the TV broadcast, the TV program that is being put out by a broadcaster. So say it's a short clip for Channel News Asia or something. The broadcasters then put it into a broadcast and communicate it to the public. Okay, they send it to the viewer. So all of these rights need to be managed. All of these rights need to be addressed before the broadcaster can send the communication to the public. Otherwise, they'll be infringing everyone's copyrights here. Okay, so this is what I mean by the bundle of rights. So as a broadcaster, you need to know that you will need the right to communicate the work to the public. As a producer, you need to know that you need the rights to reproduce all of these things and to have rights to the novel. Okay, that is the second point, which is understanding the nature of copyright and being able to piece it together. So there are basically two steps. One, identify the type of work, which is literary, dramatic, musical, artistic, sound recording, or whatever. And then two, identify what you want to do with that work. So I want to adapt a literary work. I want to reproduce a literary work. Be very careful with that when you're doing your licensing exercises. Okay, number 3, pitfall is not having a robust clearance process. So clearance, I'm sure you'll be familiar with, is the process of obtaining sufficient permissions to allow you to carry out some activity. So what I would suggest, and you're going to get these slides, I think, at the end of the session, so I'm not going to go through all of this. I just simply don't have time to go through everything, but I would suggest at minimum, you identify the works that you intend to use, how you're going to use them, whether they're protected, by who, if the terms and conditions allow you to do that, if there are exceptions that apply, and then if not, establish whether it's feasible to ask permission. And this should be a process that you integrate into your daily business of dealing with these types of works. Okay, so you can refer to these slides later on if you don't already have a clearance process. IPOS also has a guide on copyright clearance on its website, so there are resources for you there to use. I've also put together, so this is an example of a copyright clearance flowchart that I've put together of how to decide whether I'm going to use a piece of copyright work. So say, for example, if I want to integrate a piece of music into my film. First of all, I'm going to look at that piece of music and say, is it public domain? So if it's Bach, then I can easily integrate it into my film because the copyright will have expired in that piece of music. If it's not in the public domain, then I need to consider whether I would be copying something insubstantially. So say, for example, I'm only taking 2 or 3 words from an entire book. That would be insubstantial. Then I would look at the terms and conditions to see whether they permit use. For example, going onto YouTube and seeing what terms and conditions YouTube allows me to act in. So YouTube says, for example, I'm allowed to embed files into my website. So if I'm putting together a website, I can then use embed from YouTube without infringing copyright because the T's and C's say that's okay. Then if I can't find any T's and C's, I'll look for defenses or exceptions. So relatively few in the context of media. Defenses or exceptions are more prevalent, for example, for educational institutions and museums. But there are certain ones that you would need to understand. Again, I don't really have time to go through them, but this is the process. Okay, so you can refer to this process later on if you don't have the clearance process, but the key takeaway from this is that you must have some sort of process in the first place, and you must adhere to that process when you're using other people's copyright works, or you could end up in trouble. Let's time check just now. Okay, so number 4, pitfall is misunderstanding what counts as infringement of copyright. Okay, so there are many misconceptions I find that people have with copyright, and they get raised time and time again. The first misconception is that just because something doesn't have the copyright mark, it's okay to copy the thing. That's not true. It hasn't been true since the 80s. Okay, so it used to be, I think in the US, it used to be the case that if it didn't have the copyright mark, there was no copyright issue. That has since been changed, and basically on a global scale, nothing needs the C mark. The C mark is just an indicator of copyright. It is not the pre-requirement. Next one I always get is I linked to the author, so I'm not doing anything wrong with my time. That's also simply not true. If you borrow someone's car and go driving it around without their permission, and then the police stop you, the simple answer of, oh yeah, this car belongs to that guy, is not going to get the police to go away. Okay, so it's simply not acceptable. Simply linking to the author is almost never defense to copyright infringement. Next common misconception is that there is a general idea that you can copy up to 10% of a work. Now, 10% is indeed a good rough guide of how much you can copy without going into a substantial amount. So say, for example, if I copy 10% of a page, if I copy a paragraph out of the book and it's less than 10% of the article, then that would generally be considered insubstantial, but it's not a hard and fast rule. It could be that copying even 1% of whatever the thing is could be considered substantial, depending on the quality of the material. So for example, if it's a piece of music and you copy an identifiable phrase from the song, so there's a little beat that's very special, very identifiable. If I copy just that little beat and I sample it and put it into my other thing, even if it's not 10%, that could be a problem. Next, the other thing is if you get a license to use something, you're 100% safe. This is not true. You have to do due diligence on the person who's giving you the license, because there's a chance that they don't own the copyright. A common situation where this happens is that where you're dealing with a person who is employed by someone else, and the person you think you're dealing with in a personal capacity, but in fact, the person created the work for their job. So then you get a license from this person in an individual capacity, but actually the copyright owner is the company. So you should have got the license from them. Okay, so due diligence is important. And then finally, the one that kind of stumps a lot of people is that because you bought something, you can do what you want with it. I think we all know by now that that's not true. Just because you buy the physical copy of, say, Microsoft Office, it doesn't mean that you can install it on as many computers as you feel like. You have to still adhere to the licensing terms. Okay, so these are the common misconceptions and not understanding how copyright is infringed. The other one is there is a fairly complicated or fairly generic defense that you can try and apply to whatever. There's a thing called fair dealing. Fair dealing allows you to use a copyright work provided that the activities that you're trying to do basically don't interfere with the purpose of the copyright in the first place. Okay, so to establish fair dealing, the primary thing is the purpose and character of the copying. So if I'm, for example, doing something for the purposes of reporting current events, or if I'm making a piece of art out of something that used to be a piece of news, or something that was for the purposes of reporting news, or if I'm trying to give a new meaning to a piece of work, that would generally indicate fair dealing. But all of these factors are important in terms of defense. So I'll give you an example of the fair dealing defense. And apologies, I know I'm rushing through all of this, but I'm just trying to give you a flavor of some of the topics that you can think about. These are some examples of fair dealing. So for example, the indexing that Google does in relation to stuff that is kept on the web. So it indexes all of these images, and then it allows you to search for the images and find them all on one page. Now, Google doesn't necessarily get a license to take these images and display a thumbnail of them on the Google website. Nonetheless, that is still considered fair dealing because actually it gives a new purpose to these images. It actually allows users to search for them by word, and then they can go onto the website and view the actual image from the author or from the copyright owner. Google Books is another good example of fair dealing. So Google scanned thousands of books into their database without permission from the author. But what that allows people to do now is to search, full text search these books. And because in this case, Google didn't include the whole of the book for the user to see, so they cut out little bits. If you've ever used Google Books, you'll see sections of it say, this part is not available for viewing. Then they got away with the fair dealing defense in the American courts. Finally, the other kind of pointer I wanted to bring out is whether linking to something is an infringement of copyright. Now, linking to something on the internet could potentially be considered communicating something to the public, okay? Because you are giving someone access to materials. You're saying, here, use this material. Okay, so that could potentially be communicating that material to the public. However, the EU said that actually because the work is publicly available on the internet and they could access it easily themselves without your intervention, then there's no new public, so there is no infringement involved. Okay, so linking to stuff on the internet is generally preferable to copying and pasting the thing into your email or into your WhatsApp or something. So linking is generally fine. And then finally, and I'm definitely kind of rushing through this just now, number 5 is not knowing what to do once your copyright has been infringed. So you have a variety of options. Again, I would recommend a systematic policy or a systematic process before you go about doing this. So don't be a bit slapdash about this because you could prejudice your case or prejudice yourself later on. So step 1 of preparing for a copyright infringement situation is to analyze the possible claim. So you look at the copyright infringement case and you decide whether you have a valid claim. So has that person infringed your copyright, or do they have a fair dealing defense, or how problematic is it going to be if I want to sue that person in court? Now you might get your lawyer friend to help you out. You might go to a lawyer and pay them for initial advice, or you might do this yourself, depending on what your budget is like and what the topic is. Next thing to do is to gather evidence. Now, you do need evidence of copyright infringement. Now, it might be very simple. They might have a website and you take a screenshot of it. Or they may have a YouTube video, and again, you take the link to the YouTube video. Very straightforward. Or it may be pirated DVDs, something like this, in which case you need to arrange for what's called a trap purchase, and you go and buy one of the DVDs and you confirm that it's not genuine. You give that DVD to the police, and the police then carry out a raid. You might want to consider interim relief, meaning you might want to seek an interim injunction in relation to the the infringement. So you basically get the court to say, stop doing whatever it is you're doing while we decide the case. Okay, so that could be a useful thing if it's causing you instant harm. And then you decide in advance whether you are considering settling with the person. So whether you would be happy with them paying you a sum of money or whether you'd be happy with them simply stopping what they were doing. Decide that in advance because it helps later on to keep your position straightforward and understandable. Step 2, we send a cease and desist letter. Okay, so step 2, we send a letter saying, "Oi, stop infringing my copyright." You have to be very careful about when you send these letters, and for this point, I would advise definitely getting a lawyer to help you out. The cease and desist letter can be a tricky thing to get correct. You can optionally at this stage also send what's called a without prejudice letter, which is basically an offer to settle, but you have to put in big letters without prejudice at the top. Otherwise, when you go to court, you will have prejudiced your position. Okay, and then step 3, if all else fails, if you can't negotiate a good outcome, then you start a court proceeding. That is not a very good option because court proceedings are very expensive. The reason I said you have to be careful with threats or cease and desist letters is because there is a remedy under the Copyright Act for groundless threats, meaning that if you are wrong about whether the person has committed copyright infringement and they in fact have not, they can countersue you for the threat. They can say, "You've caused me damage by making me stop using this work. I want my money back." Okay, so they can sue you for that. So just be careful. Generally, you would get advice of a lawyer before you go about sending cease and desist letters because you could end up getting yourself in a bit of trouble just by sending that letter. Okay, as I mentioned, where the copyright infringement thing involves physical articles, like so physical tape, something like that, you would want to hire a private investigator to conduct a trap purchase and then liaise with the police in order to enforce the rights. Just so you know, I mean, hopefully none of you end up in this scenario. Hopefully none of you end up in this situation. But if you do go to court, this is what you would expect. So if you go to court, which is expensive to say the least, what you would expect is to file a statement of claim, which would be a document setting out what your case was. So the lawyer would help you prepare this and then file it. You would then serve that on the person who infringed your copyright, whether that was in Singapore or whether that was outside of the jurisdiction. Very complicated thing for there. You can then apply for discovery to find out what further documents and stuff and what further infringements they've committed. And then you have to prepare for trial. So this is the overall outlook of the process. In short, there are a lot of areas that you can go wrong with copyright. There's a lot of different topics that you need to consider. Now, obviously today, I've just given a very quick brush of some of the topics that you might want to consider. In order to learn more about these topics, you can check out IPOS International's business guides. These are very helpful and very plain-spoken guides for how to create IP, for how to collaborate with someone properly and how to effectively protect your IP rights. And they will include a very commercial discussion of all the points that I've gone through today. So all the 5 points about knowing what a licensing terms mean, about how to enforce your rights, about knowing what copyright is, about knowing what infringement of copyright is, and all these different topics. Okay, so you can scan this QR code or simply go onto iposinternational.com and you can check out the business guides online. There are a few of them. Also, you may want to consider after this course, if I've confused you or if anything I've said kind of sparks an interest in you, or if you're concerned about anything I've said, you may want to attend one of the more complete courses that we run. So one of the, for example, one-day courses that we run on, for example, IP fundamentals in business, which covers the copyright section, or you could look at the strategic IP management for business in partnership with SMU Academy, the one-day course. So there's all these resources available to you. Quite often they have significant amounts of funding from Skills Future or from some other source. So please, if you feel alarmed by anything that I've said today, or if you feel that you don't really have a good grasp of what copyright is and how it affects you, please do make use of your Skills Future funding to go ahead and join one of these courses. Okay, and with that, I think it's time for Q&A. So Kenneth, we'll go into this.
Thanks, Paul. There are actually quite a lot of questions on the Q&A. We will try to answer some of them. Unfortunately, we will not be able to go through all of them. Maybe I'll just start with the latest question from Jerry Coding. He asks, how does copyright work in terms of taking video or photographs commercially and of buildings, right? And where is it? I lost it. Oops. Jerry, I think Jerry took down the question. Okay, then maybe I just want to go through one question that was in the chat, was listed in the chat, and then I'll go back to Jerry if there is.
Sure.
What is the indicated cost to register a copyright?
Yeah, so I mentioned, I think at the start, so copyright is not a registered right. You can't register copyright in Singapore, so there are no costs. The costs of obtaining a copyright are the costs of getting a pen and pencil to write down your literary work, or the costs of getting a camera to film your cinematograph film. There are no registration costs. There are registration costs in America if you want to sue for damages in America. But even in America, you don't need to register in order to get some copyright protection. So there's none, no costs. The only costs of copyright are involved in licensing. So if you wish to in-license something, then you'll need to pay for that, obviously. Or if you are enforcing your copyright by suing someone, then you'll have to pay the lawyer's fees, the court fees, all this sort of thing.
Thanks, Paul. Okay, back to Jerry's question, how does copyright work in terms of taking photos or videos of commercial buildings that are publicly recognizable? And when do you need to get the permission from the building management or the owner, and what are the rules of that in Singapore?
Good question, because a lot of people wouldn't necessarily think of buildings as being copyright protected works, but they are. So the architect who drew the plan for the building then constructed that building in 3 dimensions. So the building is actually an artwork created by the architect, which causes a problem, right? Because a lot of photographs and films are taken outside. So to that end, the Copyright Act provides that the incidental inclusion of a building in a film does not constitute copyright infringement, or taking a photograph of the building if it's in public doesn't constitute infringement of copyright. Okay, there's a specific section, and this is what I was talking about, the bundle of rights that forms copyright. It's not easy to understand sometimes how they all fit together, but there's a specific exception in the Copyright Act saying you can take a photograph of a building which is located in public. Okay, so no issue with taking pictures. Otherwise, every tourist in the world would be guilty of infringement. So some common sense there.
A question that has been asked a few times, memes and parody songs, would that be created? I mean, once this created, would it be considered fair dealing?
So there's no specific guidance about this in Singapore, but we can look to the UK for the answer to that question, because in the UK there is a specific parody defense under the fair dealing category. So I think in Singapore we would probably follow suit and say that under the fair dealing category, memes and parodies are okay to do. So if I'm taking, for example, a politician's speech and I'm making fun of it in some way, or I'm making a comedy sketch out of it or something, then I think we could say this is fair dealing, because we're either doing it for the purposes of satire or we're doing it for the purposes of comedy, and we're not really reusing the original materials for the same purpose as they were originally created. So in that sense, it depends on the exact nature of the meme or the exact nature of the parody song, but you could, in all likelihood, use the fair dealing defense to say, actually what I did, repurpose the original thing into some different meaning. I've given it some new spark and meaning, which means that you can attract this fair dealing defense.
Thanks, Paul. Thank you. There's one question about, actually, there are a fair bit of questions about songs and adaptation of songs as well as books, but I want just to go to one first, by Kelvin C. It says, hi Paul, businesses are often featured in magazines and on newspapers, so business will reproduce this article on their website with credit to the publisher, of course, but some companies do not allow it unless the business pay for it. So how does that work, and what are the rights for the business to be that's being featured?
Okay, yeah, good question. So the subject of a copyright work doesn't actually get any rights to the copyright. Okay, so if you come and interview me, and then you create a biography about me, well, that would be the most boring biography in the world. But if you did that, it would be your copyright in the literary work of the biography. So I would need to negotiate with you for the use of that work. So in the case where the companies that are writing these articles about the businesses, say for example, SPH does an article about TWGT, then in the process of discussing whether we could do that article, as legal counsel, I would ask SPH, can we have the right to reuse this article on our website? If we don't get that right, then technically by hosting that article on the TWG website, we would be infringing copyright in the SPH's article. So yeah, good question.
Just a rejoinder to Paul. I know of an incident where a company was featured in an interview by SPH, and the company, after the interview was done and the article was published on the papers, the company went ahead and put on to the website without consulting SPH. SPH basically asked the company to for a fee. I mean, they're okay, provided provided a small license fee to put up the article. So it is up to them, to the company, to say, okay, I'll pay you X amount of dollars, and then the thing stay there, or just basically take down the article from the website, which they did, and then subsequently they got that the pay of the fee. Yeah.
And SPH has done this a few times actually, because Yahoo at one point was copying articles or indexing articles, and SPH actually got Yahoo to stop doing that on the basis of their copyright claim. Yeah, so it does happen. It does happen.
A question by Haida. What about names? For example, they're coming up with a movie and the name is called Rock. Will it infringe any? Will it cause any infringement?
I think in names, generally short pieces of text or headlines are not sufficient enough to attract copyright. So they don't contain enough of the intellectual creation of the author. So if there's a headline that says, for example, five injured in car accident or something, this probably wouldn't attract copyright because it's too generic, too simple to attract copyright in the first place. So the name of a film also probably wouldn't attract copyright, depending on the name of the film. If anyone's interested, the case that would give you more guidance on that one, if you're interested in reading a legal case, the case is called InfoPack. Okay, it's an EC European Court of Justice decision that discusses when small headlines and short pieces of text can attract copyright. So generally names of films, I think, wouldn't. So there could be many films called Rock or The Rock or something. The problem there might be with trademark infringement rather than copyright infringement. Okay, so if I'm using the same name of film, am I kind of misrepresenting to people that it's some way connected to the producers of the earlier film? That would be a trademark issue rather than a copyright issue.
Thanks again, Paul. There's one question on the chat group asked by Gerard. He is asking, are there ways to prevent unauthorized copying of electronic files? Before I throw the question to Paul, I mean, I don't know what particular e-files, electronic files, Gerard, you're referring to. But if it's video files, what producers sometimes do to protect the particular title is obviously we tend to watermark it either across, in some form or manner onto our video when they are trying to distribute or put it on some, distributor website or something like that. Usually, the producers will not, just put it a clean, what we call a clean video, but will be a watermark. But I don't know what other files. Paul, you want to come in and jump in here?
Yeah, so you're totally right. I mean, there's not any hard and fast way of doing that. So there are things like watermarks. There are things like if it's a PDF, for example, you can secure the PDF from printing to prevent people from reproducing it. If it's YouTube, you can use YouTube's Content ID to address and take down infringing copies of your video, and it's relatively smart. You can use encryption in certain ways to prevent people from accessing the material if you don't want them to, but there's no real 100% foolproof way of preventing people from accessing electronic materials. Unfortunately, that's just how it is. And people publish, if it's a game that you're producing or a film that you're recording, you'll know how difficult it is to prevent people from uploading it onto, for example, the Pirate Bay or one of these torrent websites and letting people download it or crack it. Yeah, so there's no particularly easy way of doing that. Watermarks, the copyright logo, securing the file from printing, all these things are good. All these things are useful.
Thanks. We have one question from an anonymous attendee, and he or she asks, would doing song covers, I think it's related to parodies and all that as well, would doing song covers and posting them on YouTube be copyright infringement? And does it matter if we are using the original soundtrack or re-recording the entire song, including the background music?
Yeah, so if you're doing a cover of a song, then you will be using the original literary work and musical work belonging to the original author. So if I want to record a cover of Coldplay's, I don't know, Yellow, then I'm using the lyrics of Yellow and I'm using the soundtrack of Yellow to do that. So I would need to get their permission. Now, there are organizations that can help you to get permission. So obviously, unless you know Chris Martin personally, it's going to be difficult to get in touch with Coldplay, right, to ask for permission. So in that case, you would go to an organization called Compass. Compass is a collective rights management organization that kind of addresses the rights in relation to a wide number of performing artists. You may, if you're a performing artist yourself, you may be aware of who Compass are because they probably give you some of your money. Okay, so they are collective rights management. So you go to Compass and you say, hey, I want to do a cover of this song, and they'll help you from there. So it depends on whether you want to do the cover for purposes of recording and uploading to YouTube, whether you want to do the recording for the purposes of performance at a gig. These all have different considerations, but Compass is the first stop. So you go to them and say, hey, I want to record this cover, what do I need to do? And they'll tell you, actually, we don't have that. We can't do that for you. Go to these people, or they'll say, okay, you need this license from us.
Okay,
yeah, that's it.
Thanks. Sorry guys, we are almost running out of time. I'll take on one question, but I'll put in one question, my own question to that, add to it. Maybe I'll just give it to Paul, and then we'll close off. It's from YL. YL asks, she has written, or he or she written a book, but yet to publish it. But the draft has been sent to several publishers. So can he or she claim the copyright? And as a follow-up question, if, let's say, Paul, if the producers, they are talking to a couple, I mean, they're perhaps someone, either a publisher or an author, what are things in this light, what are the things that they can, in terms of they are looking at adapting, obviously, the book into a TV series or a documentary, what are things that they can start the conversation going?
Yeah, I'm sorry, I'm just looking at the question, and I think the important thing here is that if you're sending the book to the publisher, the first thing I would be asking you, if you came into my law firm or you walked in and asked me a legal question, my first question would be, when you submitted the book draft to the publisher, did they have any terms and conditions? So for example, if you submitted the draft on a website, or did you sign a contract, you would need to look at that contract to see what rights you have given them. Now, assuming that you haven't signed anything and you've sent the book to the publisher for them to review and read, then actually you still have the right to publish it, and they're not allowed to publish it without your consent. So that's the first thing to note, and they're also not allowed to make copies of it without your consent. Really important in this case is to work out whether you've signed or agreed to anything, because if you have, chances are the publisher will put into that agreement a thing saying, we are entitled to publish it, or we're entitled to copy it at our discretion, and we'll pay you X amount or something. So this is the part where you need to be careful about managing your rights. What exactly are you giving away by doing certain things? And this is one of the cases where you could accidentally end up doing something you didn't necessarily intend. So you'd want to then negotiate with the publisher about, what are the royalties going to be like? Where are they entitled to publish it? Are they going to be the exclusive publisher? Because then if they're the exclusive publisher, you want some obligation on them to actually publish the book. Because if you make them the exclusive publisher, they may choose to just not publish it, and then your work doesn't get any money and you don't get any royalties. Okay, it does happen. And I know it sounds stupid, but it does happen for various commercial reasons. So if they're the exclusive publisher, you would want to say, okay, you have an obligation to market and sell this book or something. So very important to negotiate these terms. And again, if you're not quite sure what terms to negotiate or what any of the terms mean, then do seek help. Do seek advice from friends who are lawyers or friends who are know something about IP contract negotiation, or come to IPOS and we can point you in the correct direction. Also, at this point, refer you to the business guides, which will address some of these issues, especially for that question about publishing a book. I would say look at the IP creation guide. There's a business guide on IP creation, which will talk about this sort of scenario.
Okay, so I will ask Paul for one more question. But in the meantime, Peter, you want to throw out the poll and get our audience to perhaps answer the poll at this point in time. Thank you, Peter. Thank you, Peter. Okay, so one of this question is actually, hold on. Right, as the poll is out, perhaps you can spend some time to answer that. Help us with the feedback. We would very much really appreciate it. So I'll just ask two questions here, Paul, if you don't mind, right?
Yep.
One is how does fair dealing work in a university setting, and especially where there are fees, charged for the course? That's perhaps this question, and I'll ask the other one.
So fair dealing in a university setting, I think generally if you're doing something for educational purposes, there's a higher likelihood of it being considered fair dealing. Now, that really depends on the nature of the work in the first place. So I do quite often give courses for people at MOE, so people who are teaching regularly, and they ask, well, if I'm copying this textbook for educational purposes, is that acceptable or not? Is that fair dealing, or is that something I'm allowed to do? Now, if the textbook is specifically designed to be used in the education industry and you are copying it, that doesn't seem particularly fair. That seems like you're actually taking away the profits of the person who generated that material for no good reason. However, if the material is not for educational purposes, then using it for educational purposes might have a higher chance of getting through the fair dealing defense test. In an education setting, also, there are a variety of different defenses that people can apply. So if you are engaged in a course of education at an educational institute, such as NUS, SMU, something like this, you're allowed to make notes as much as you want. So as long as you're handwriting or typing your own notes, you can make notes that are basically copyright infringement of any text, because you're making personal private notes for yourself. So that's something that you can do. It's called if you want to search that in the Copyright Act, it's called non-reprographic copying. Big fancy word for doing it by hand rather than using a photocopier. There's also various exceptions for when you are using materials in libraries. So in libraries, you can copy a certain percentage of works using the library photocopiers. That is permitted under the Copyright Act. If you go into the National Library, you'll see the big sign beside all the photocopiers telling you what you can do and what you can't do. So different rights, especially in education, I think I mentioned.
Yeah. There is a question about IPRO actually, so I'll answer that question. And the question is, what action would IPRO take against members if they infringe copyright or another, or is that sentence in the court of law? Right, IPRO is an association that represents the interests of our members. I mean, like we mentioned earlier in the beginning, we will engage our stakeholders with it. With regards to copyright infringement by or alleged, copyright infringement, do talk to the member concerned if there are any. We do not know right at this point in time what are you referring to, but if there are, talk to the particular production company, engage with them, and then discuss with them. If there are obviously enforcement actions. If you think that you feel that your copyright is being infringed, then obviously there are recourse to you if you are the copyright owner. So have I mean, as in everything, have a conversation with, like what Paul mentioned, right? Have a conversation with the particular alleged person or company or what have you, and then go and discuss it. And then if you think that you need to go to pursue legal recourse, then get legal advice for that.
Yeah, I want to just. Can I just on this point? There's been a few questions. I'm just looking in the Q&A and on the chat. There's a few questions about the kind of dispute resolution process and what that would involve, right? So I think in these cases where someone's infringing copyright, You have two types of infringers. You either have a licensee who's doing something that you don't like or breaching the license term, or you have someone who's not connected with you. Now, you have to deal with these two people differently. If it's a licensee, you might want to consider inserting into the license, like at the start, an alternative dispute resolution clause. So someone has mentioned this before. So that would be, for example, an obligation for the parties to go into mediation if there's a dispute, or an obligation for the parties to go into an arbitration. And this would save costs on the court fees because it's resolved privately, or at least you attempt to resolve the thing privately rather than going to court. So these are good things to include. Again, you may want to get legal advice on exactly what words you use for this and when it would be appropriate to include it. But yeah, alternative dispute resolution is a good idea. Another question that somebody's asked is do most of the cases get settled out of court? Yeah, in my experience, they generally do, because the parties don't want to incur the expenses of going to court. So just for information, if you go to the High Court for a copyright case, typically you're looking at upwards of $100,000 for the total cost of the case. So that would be a quite basic case. If it's a more complicated or more complex case, you're looking at much higher fees. So that's a lot of money, and you don't get all of it back even if you win. So it is in everyone's best interest, and the courts actually promote this. They actually want people to resolve the dispute before going to a decision, because they actually just want the dispute solved. So if you can solve it on your own through mediation or through negotiation, that is the best outcome.
I mean, in everything, there's always a conversation, talk and then go to a mediation setting where things are more neutral, and before you even consider any recourse action. Thanks, Paul. With that, unfortunately, we have come to the close. We have overrun some time. Thank you all for joining us this afternoon. It leaves me now to thank Paul and IPOS team from IP Academy, from IPOS International, as well as IPOS itself, for coming together with IPRO to organize this event. I hope you have come away with some meaningful thoughts about that, what you are able to look at in terms of the pitfalls. And remember the 5 key takeaways for the session. Number 1, copyright protects your original IP, your creation, taking precaution with regards to looking at the dealings with the T&C, having a robust copyright clearing process, and then understanding what are the bundle of rights within that copyright, and then finally, knowing the steps when you can take, just now when Paul and I were talking about, when your copyright is being infringed. So thank you very much, guys. Thank you for spending this 1 hour and 15 minutes with us. Thank you all for coming. This will not be the end. Like Paul mentioned, there are some other courses IPOS has already organized and it's already planned out. IPRO and IPROS, so we're talking to do some further courses so that we can benefit and really particularly to our industry. So with that, thank you very much. I'll leave you now to Paul. So the deck will be sent to the attendees. The session has been recorded, and it will also be sent only to the attendees. If there are no further queries, I will just close off the session. And again, thank you all for coming. Thank you, Paul, for sharing and spending that 45 minutes with us. Thank you, guys.
Yep. Thank you for listening, everyone. And just to add on to what Kenneth said, is that if you have any remaining queries, I know that we didn't get around to all of the questions, but if you do have any burning questions that you want to ask, I'm more than happy to answer them. So just email me, paul.mcclelland@iposinternational.com. Okay, so feel free, if you did ask a question I didn't get around to answering it, then you can let me know and I'll try and answer it by email. Okay.
There are a lot of questions, Paul.
My inbox is going to get flooded.
You're going to get flooded for sure. All right. Thank you very much, guys. With that note, thank you all, and leave me out to thank you once again. Thank you, guys.
Okay,
thank you all for coming. Bye-bye.